listening to A State of the Union, Estate Planning Made Simple. Here's your host, Brad Wiewel, from Texas Trust Law in Austin, Texas.
Hi, this is Brad Wiewel with Texas Trust Law. Welcome back to our podcast, The State of the Union, where we talk about all kinds of things that have to do with wills and trusts and probate, charities, some kind of interesting things every so often, movie reviews, for goodness sakes. And today we're going to kind of do a greatest hits. How about that? We sent out a blog post that you can subscribe to off our website, Texas Trust Law. And Wade is our director of this podcast. He's also the one who creates and puts up the blogs. And he came to me and said, Brad, we've really got a couple of topics that have just gone through the roof. People are very interested in these topics. The topic we're going to talk about today, at least in the first part of this broadcast, is estate planning is critical for a single parent. So let's talk about that. I'm going to give you some highlights, and then if you want to come in for a company consultation, of course, we're always happy to see you on that basis too. Of course, we deal with lots and lots of single parents of minor kids and adult kids. I spent about 10 years of my career doing family law, and it's a hard life, it's a hard practice, it's a rewarding practice because you get to help people kind of at their worst point. There's a phrase out there that says, frankly, in criminal law, you see bad people at their worst because they get fixed up for court. In family law, you see good people at their worst because they're going through this awful thing. So if you've been through a divorce, or maybe you were a single parent and never got married, but you are a single parent, let's talk about what you need to do. Of course, the first thing you need to do is take care of yourself. And what I mean by that is we need to get you medical documents, a medical power of attorney so somebody can, a medical decision for you, a living will so somebody can pull the plug. We got to get you this thing that very few people know about, and frankly, very few lawyers use. It's called a HIPAA release, HIPAA. HIPAA is a health privacy law, federal health privacy law. If you don't have a standalone HIPAA release and you rush to the hospital and your family shows up, they cannot talk to your family about your medical condition because under HIPAA it's private, and that includes your children too. So we need to get to that too. And another thing we like is a document that says I want to be buried or cremated. So he knows that too. So it's first about you. Okay, so somebody can access your money to take care of you and your children, for goodness sakes, right? And if they're minor children, they're thoroughly dependent upon you. And of course, there's probably in those situations another parent that they can be dependent upon too. But so often the other parent isn't around, isn't available, isn't involved. So let's take care of you, and let's make sure you have the authority you need to take care of your kids. So let's go to the kid part of this thing. What do you need to take care of your kids if you're alive and incapacitated? We're going to get to the death part here in a few minutes, but let's talk about you alive in that car wreck, on Mopac, on 183, on I-35, on 130, on BK Road, wherever the hell you are. You're hurt, and somebody's got to take care of you, but we also have to take care of your kids. So one thing we need to do is make sure you have a financial power of attorney, and a financial power of attorney is a legal permission slip, and if I can't sign my name to a legal document or a check or an investment account, you have my permission to do this. Well, you certainly need that so that somebody can take care of your money, and if your children are minors, then with that, they can also take care of your children, okay? But the problem with powers of attorney is that financial institutions don't like them and could refuse to accept them. So we oftentimes do living trusts, a revocable living trust, which is a similar type of document, but more powerful. And a revocable living trust has qualities about it that require financial institutions to accept them. With the power of attorney, they can decide if they want to or not. There is a law. We can push it. And if we push it and we win, and they take it. If you lose, well, you've had to hire an attorney and pay an attorney and go to court with an attorney, and maybe you lose. They don't take it, and you have to pay their attorney's fees for fighting you. So it's a complex thing. If you have a smaller estate, less than $1 million, a power of attorney is perfect. If you have a larger estate, a trust will be much more perfect because, again, the more money you have, the more reluctant these institutions are to accept a power of attorney because they can never be sure this is the right one. And with a trust, as kids age, we can put things in there about, of course, put my kids through college, of course, pay for their expenses until a certain age. With a power of attorney, you really can't do that. We really don't do that. So, again, with a trust, you can do more for your kids if you're alive and incapacitated. If you have children that are incapacitated, autism, Down syndrome, just something that's going on out there, there's somewhere on a spectrum of some ilk, then again, we can put more details on caring for your child in a trust than we can in a power of attorney. So those who are out there, you need to be aware of that. We also need to get you to appoint a guardian. Now, this is where you're not going to like what I'm going to tell you, but I'm going to tell you this because you need to know. This is imperfect stuff, and we don't make the law. Okay? The law says if you can't raise your child for whatever reason, you're either incapacitated or dead, your other parent, the other parent of your child, becomes their managing conservator because you can't do it. And a lot of people find that distasteful, and certainly it may be distasteful. I have no idea who your ex is, and oftentimes exes are exes, of course, for a very good reason. They're not a good person, but the law says they're the natural parent, they get first dibs. It is very difficult to overcome that. There are very few people that can even challenge it in court because they don't have this thing called standing. And you don't have standing to challenge it unless, well, there's several reasons to do it, but one is that person who wants to challenge the natural parent's ability to be the guardian has to have lived with your child for 6 months. Maybe that's your new spouse, maybe that's your love interest, but it is hard to do, expensive to do. So you just need to know that's there. But we do give our clients a document. It's called a declaration of guardian, where you can say, if that person's not available, or maybe they're gone, I want you, judge, to pick this person. Okay? And then the judge has to pick that person again if the other parent is not available or the other parent's not fit. So you get control, and we give you this document to say who gets to raise your children, not just if you're dead, which is what the vast bulk of lawyers do. They put in your will. We have this separate standalone document that allows you to appoint somebody to do that even if you're not dead, because your will's not effective until you're dead, but if you're also incapacitated. So you might have figured out a huge part of our focus in our practice is taking care of you if you can't take care of yourself, and take care of your kids if you're not there to be able to take care of them. So, all important stuff. The guardianship stuff is very difficult sometimes for people to swallow, but it is the law. But let's talk about money. Okay, this is where the rubber really meets the road in these things, and I can't help who's going to raise your kids, perhaps. We don't do family law. If you have that issue, we'll refer you to a family lawyer to fight it out in probate court, or who's going to be your child's guardian to take care of them physically. But your money is a completely different deal, and it's a completely different big deal. So if you have minor children, you have some assets. You may have a home, you may have a car, of course, you probably have some savings, some accounts, maybe you have a lot. Investment accounts, whatever. When you, A, become incapacitated, or B, pass away, you don't have to let your ex control that, okay? You can set up structures, particularly a trust. You can put a trust in your will, so if you die, they don't get it. And when you're incapacitated, again, we're using the power of attorney, and your ex's name won't be on that too. But you get to control who manages your money for you and for your children if you're alive and incapacitated, and you do get to pick who manages your money if you're gone. Well, this is a big deal. Back to my 10 years of family law experience, a lot of divorces happen because one spouse, one parent is crappy with money, okay? Or they don't respect your money, and they won't respect your money, and they'll spend all your money and maybe not their money. So you get to pick, and you get to pick somebody who becomes the trustee of your children's money, and they will have control of it, and they can distribute it, but only in a way that they think is advisable. And the way we set things up, typically the other parent can't force a distribution, okay? We want your children to be taken care of well, and the trustee can do a lot of stuff, but we don't want the ex showing up demanding more stuff. My kids need another trip to Europe this year. They need a brand new car this year. They got one last year, need another one. It's a year-old car. Don't you realize that? It's old, and I need new, cool stuff, okay? The trustee can control that. But ladies and gentlemen, if you don't do the planning, or you don't do the planning well, guess what? Your ex is going to control your money if you're gone too. The money you're leaving your children, these are minor children I'm talking about, they get control that money for your child because they are the natural guardian of your children. So they'll get to manage the money, and they'll get to raise your child. And I don't know how much money is going to be left in the long run for your kids if your ex gets it. They will have to report to the court, blah, blah, blah. Well, but, away it goes. If you do the planning, again, we can't help this who's going to raise your kids stuff much because the law really gives the surviving parent a big leg up on that, a huge leg up on that. But money is something different. You can come in here and we can do a will, we can do a revocable living trust and let you name somebody who will control your money for your kids. Being a single parent, you work hard for that money, and you sacrifice a lot for that money, and you certainly may be getting child support, maybe you're paying child support, but your money is your money, and if you want to control it, the law lets you, but you only get to do that if you do the planning. And it's so sad to see people come in here with a problem, and they didn't do the planning, and things go off the tracks, and they go off the tracks because you let them go off the tracks, because you didn't do the planning. So this is big stuff, obviously, serious stuff, obviously. There are other things you can do. You've got to be careful about who your beneficiary designations are on your retirement accounts, perhaps at work, or maybe you've got a separate IRA. If you've got life insurance through work, who the beneficiaries of that are. You got to be careful about naming your kids. Again, minor kids can't own property. And you put your kids down because that's all you know how to do, and then you're gone, and then the ex shows up to manage that property too. But if you do it right, they don't get that either. They don't get that either, okay? So there's a lot of little things that go on here that certainly aren't obvious, but are important. We can help you with that if you'd like our help. Certainly there are other lawyers out there that could maybe help you with this as well as we could. We do a great job. We're Texas Trust Law, and we offer a comprehensive consultation to sit down with you or someone you love, maybe your grandma and grandpa. And you've got a daughter, you've got a son who has children that's been divorced, or maybe there never was a marriage, but you have grandchildren. Send them over. Come and see us. The first meeting is free. What was that word? Free. We have 8 lawyers here. We can sit down with whoever we think is the appropriate lawyer and help walk through these issues and get the help that people need. So we're happy to hear from somebody if you need our help, but you've got to take care of this, or the worst case scenario is waiting to happen. Thanks for your time. This is Texas Trust Law. This is the State of the Union, and we'll look forward to seeing you on another podcast soon. Thanks again.